All right, the court is calling 2020 CR 12332, State versus Azie David Ibara. That parties announced.
Megan Galloway for the state.
Dennis Callahan, defense.
And are you Azie David Ibara?
Yes, Your Honor.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Azie David Ibara who's placed on deferred adjudication in 2020 CR 12332 for the offense of robbery on July 14, 2021 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 5 in Bexar County, Texas. The defendant, Azie David Ibara, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, December 2023 in violation of condition number 5.
All right, and is that the supplemental?
It is, Your Honor.
All right. Did you review the supplemental with your attorney? Did you understand it? And
Yes, Your Honor.
all right, then to that allegation, how do you plead? True or not true?
True.
State.
And in violation of condition number 5 in Bexar County, Texas, the defendant, Azie David Ibara, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, December 2024 in violation of condition number 5.
How do you plead to that? True or not true?
True.
And we'll waive and abandon the remainder, Your Honor.
Any objections?
No objection.
Did you understand by pleading true to 5 and 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to 5 and 5?
Yes.
Court will find 5 and 5 true. Is there a proposed agreement?
No, Your Honor, the state is asking that you grant the state's motion, adjudicate the defendant guilty, revoke his community supervision, and sentence him to 7 years in the prison. And that is based upon the pleas of true today and the fact that this is the defendant's second MTR. He had an MTR back in 2021, and at that time, the court had ordered some evaluations to address any issues that were of concern at that time. And then the probation the probation department has not heard from him since the end of 2022. And that's why we're asking for that.
All right, defense.
We propose as, or ask the court to consider as the first alternative to put him back on probation, perhaps with more supervision. The court's not inclined to do that. We ask the court to consider the court summary submitted by the probation department talking about an inpatient, say P or ISS. We would propose that as a solution to the problem of his not reporting. Nothing further.
All right. Is there anything you wish to say?
The last time you saw me,
Raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Azie David Ibara.
All right, what would you like to say?
I would like to say, Your Honor, the last time you saw me about 4 years ago, as much as I was at least 22, I would say I would have then the mind of a child as during my early childhood years, I suffered years of sexual, physical, and mental abuse that well into my adult years, I would have years of trauma. And I would say that then when you did see me, I did not understand the gravity of the situation, nor did I understand the consequences of my actions. I would ask that the honor here today would please have mercy on me, as I am confident enough to say that I am not the man I am used to be. I am not telling you here today, Honor, that when the day I walk out, I am changing my ways. I'm simply saying that I am changed. I am no longer the man that I was. Over the years of being quote unquote on the run, I experienced more of life, and the fact that I had two children, one of 1 year old, a baby girl, and a 6-month-old boy. And they gave me purpose in life, Your Honor, that made me want to be a better man, Your Honor. I would ask that you would please have mercy on me and grant a reinstatement or probation, Your Honor, with stricter things, Your Honor.
All right, any questions?
No questions.
State, any questions?
No, Judge.
This is the critical moment for the defense. With no agreement and the state asking for 7 years, Mr. Ibara takes the stand to humanize himself. He's citing a history of severe abuse and trauma, a classic mitigating factor. But will his emotional plea of "I am changed" and the mention of his 2 young children outweigh the fact that this is his second violation and he disappeared for 2 years? What would you do if you were the judge?
All right, so what I'm going to tell you, sir, is that you had a previous motion to revoke in this court. And that was a violation of condition number 5, not reporting. And you had that violation of condition number 5, not reporting, and you picked up new charges. And those new charges were misdemeanor charges, and I think those were assault charges. And now you're back here again for the same thing, not reporting. I don't think you're a good candidate for deferred adjudication or a good candidate for probation. So I'm going to grant the motion, find you guilty. The state is requesting 7 years. What would you be requesting, defense?
Considering the time and difference of the date of the offense and where we are today, I suggest 3 years, Your Honor.
All right, and there is a request for restitution that was to Christian Fossell. Probation, do you know if that was paid or if there was a restitution amount?
Judge, there was nothing indicating restitution.
All right, the court is finding 5 and 5 true. The court will grant the motion, find you guilty. There's to be no contact with Sylvia Montez Casimir, Kazmire. There's to be no contact with Christian Fossell, and the court will sentence you to 7 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
7 years, Your Honor.
Yes. Because this is not a plea bargain, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. Make sure you do better and make better decisions. All right, Freddie Gonzalez. Hello. Why were you late for court?
Rush in the morning. Well, I'm staying in a hotel in the morning and had to get all my
I'm
stuff out.
sorry, what?
I'm staying in a hotel right now. I had to get all my things out.
All right, you have a number of cases on this docket. You cannot be late for court. Do you understand? All right, what is happening with all of these cases?
Your Honor, the last time we were here with entered a plea, he was placed on probation.
Mhm.
He was given 10-day jail sanction, which he's completed already. He was ordered to pay restitution on part of the restitution the last time we were hearing for it. And then we have the final sum of restitution that we are in agreement.
Can I
with.
see the file on this, please? All right, so if y'all can step back a minute so they can get the information on this restitution issue, okay?
Okay.
Who else?
Azie Martinez. Page 4 at the bottom.
All right, Matthew Martinez. State, did you tender an offer?
Yes, Judge.
All right, how old are you?
I'm 25.
All right, Ms. Ferguson, set this in 3 weeks for a plea deadline date, please.
November 20th.
All right, we're gonna be back on November 20th. At that time, you need to let the court know whether or not you've reached an agreement. If you have not, there's gonna be a quick turnaround for a jury trial. Do you understand? All right, and state, if you can have an acknowledgement of discovery completed, please. Thank you.
I can just maybe excuse.
Once you sign the acknowledgement of discovery, and he does the reset form.
Thank you.
All right, Mr. Cox? Are you ready on Mr. Johnson?
Okay.
And then is the plea paperwork ready on Kelly Green's client?
Yes, ma'am. So we have-
All right, Mr. Johnson?
Yes, ma'am, I'm here.
All right, if you'll show your video, please. All right, so what is,
There's part of it was discovery judge, and
Mhm.
there's some outstanding discoverable information I need from the state. And hopefully they can get that information to me.
I will have it done if the court would give us, I know you've given us discovery before, but I've not conferred with Mr. Cox about what he's requesting this time specifically. And so I've identified exactly, so 3 of the requests I know that I could have done in 2 weeks, but there is 1 request that I'm gonna have to bring in some witnesses for, to dig deeper into what is needed to comply with what he's asking.
all right, Ms. Ferguson. I need a 30-day reset. This is gonna be discovery and plea deadline date. You all will need to confer off docket.
Yes, ma'am.
All right, it will be December 1st.
Excuse me, Your Honor.
Yes,
I was wanting a speedy trial because these cases have been setting back like what I want to do in life. So I just wanted to ask for that. I know it's been like a year, and like some of my cases they weren't filed within like a year. Within like a year, I'm sorry.
This is a classic courtroom conflict. On one side, the defense lawyer, Mr. Cox, needs critical discovery, information from the state to build the best case. On the other side, the client, Mr. Johnson, is frustrated and wants a speedy trial. This is a tug of war between the Sixth Amendment right to a speedy trial and the constitutional right to effective counsel, which requires having all the evidence. If the lawyer isn't ready, the trial is a huge risk. Who wins this argument?
tell you, you'll need to talk to your attorney about that. What I can tell you is attorneys do not like to go forward if they are requesting specific discovery. Usually, and this is just my experience as a prosecutor, usually what will end up happening is the state will receive the evidence they feel that they need to prove their case. And that's what will be turned over. Sometimes the defense attorney will see things differently and will request more information. So your attorney is saying that there's more information that he wants before he proceeds. However, if your attorney wants to proceed without that information and you want a jury trial, we can have you have a jury trial in November. Mr. Cox?
My preference would be to get the additional information. I think it would be in my client's best interest, but
All right, so what we're gonna do is we're gonna bring this back. And if your attorney wants it brought back sooner for a jury trial, and the 187th, we're always accommodating with jury trials. We're in trial every week. So your date is December 1st, but if your attorney determines that he wants to proceed without that information, we will proceed and we will have your jury trial in November.
Yes, ma'am. Understood.
All right, thank you so much, and thank you for dressing appropriately.
Yes, ma'am.
Enrique Soriano, who's the attorney?
Yes, Ron Ross had an appointment this afternoon and was not able to come back for this. I did discuss with him, defense has come with a counter offer. However, it is a plea recommendation from DA Gonzalez, and I need to approach him and see if he will entertain changing his recommendation. I could not do that today. I'm not sure that I'll be able to do that this week, so I do need a little bit of time to do that before we make a decision.
All right, Enrique Soriano, come down, please.
There you go, Judge.
Have a good one. What's up? All right, bye-bye. They told me you were looking for me. I thought you were coming down to try a case. All right, so we're gonna recall this in 2 weeks. That's it, 2 weeks.
Lesson time. The defense has a counteroffer, but the key hurdle is that the original recommendation came from D.A. Gonzalez himself. In many jurisdictions, a district attorney's personal recommendation holds serious weight and is tough to overturn. The defense attorney needs time to negotiate up the chain of command. When a case involves a DA's explicit offer, it adds layers of political and bureaucratic complexity to the plea negotiations.
Ms. Ferguson, I need a 2-week reset. All right, that's gonna be your plea deadline date. All right,
Yes, Your Honor.
and there'll be no further extensions.
Thank you, Judge.
All right, thank you.
Judge. Excuse.
Yes. Kilo Kimliker.
Present, Judge.
Hi. All right, so is everything okay with you now? All right, so where are we on discovery? Because I know at one point he was in the hospital, then you were in jury trial, so this is sort of the beginning of things.
Oh, no, I think.
That's what it said.
The previous court appointed
Attorney was in the hospital, yes. All right, so what is happening with this
So,
case?
Been getting discovery, Judge. It seemed the state, excuse me. No, somewhere else, sorry, Judge.
No problem.
The state let me know that there was a pending charge that was just indicted.
Mhm.
On this case, and so I think that's gonna supersede the current 2 charges.
All right, and Norma, if you can make sure that he is on the new case.
Thought you.
Are you already on that case?
Not, Judge, only because I'm not on the list for capitals,
Mhm.
but I can still be as.
Well, I would like to keep you on. Let me see. Just one moment. If you'll have a seat, please. And then Norma, for this, I need a reset date, the last week in December. All right, so, Mr. Cabanas, it's gonna come back on December 18th, but before you leave, if you can look at the list and let me know.
Yes, Judge.
Could I see Yvonne Pettis? Kelly Green? Kelly Green. All right. As soon as she's ready, we'll come back at you. Who's the next one? Antonio Garcia. All right, so the plea deadline date for him was October 28th.
That's correct, Judge.
Where are we on that?
We need to move towards trial, Judge.
All right, so Ms. Ferguson, I need a jury trial date for Mr. Garcia.
That's fine, Judge.
All right, your jury trial date will be December 9th.
We did also want to address the
Violation,
violation
yes,
violation issues. As the court knows, I was in jury selection.
yes.
Wasn't able to do that. Judge, given that I wasn't here when you made a ruling on that, we were trying to figure out exactly what the court had ruled.
I had issued a judge's warrant, and part of the reason for the judge's warrant were we were supposed to hear the violation report. Then he left, then he came back. And I think you were here and he had left, and then he didn't, then he came back later.
Well, no, what had happened was, Judge, I was here in the morning. We took a break for lunch
Mhm.
and I wasn't available in the afternoon, so Jessica Gonzalez was nice enough to step in.
Mhm.
So what I'm asking the court to do is reconsider that judge's warrant.
Mhm.
I know that the court wants to, and we talked about some inpatient as a condition of bond right now.
I mean, previously he was in lifetime recovery.
Yes.
And obviously that didn't work. They removed him from the program because he continued to test positive. So it's obvious he needs treatment.
Mhm.
Otherwise, it's probably not going to end well for him.
Well,
So what do we have in terms of treatment for him?
Inpatient. Well, I mean, obviously the court's looking, if we've tried outpatient, and obviously the court would be looking at inpatient.
Mhm.
It's very rarely does this come up where we have to talk about this issue on bond, so.
Yeah.
I'm right offhand, I don't know what our issue, what our opportunities are.
Well, he's saying that when Jessica was here, Jessica said that he had insurance
He
and he
does.
could do that. So the question becomes whether or not he's willing to do that and
Okay.
when would that take place?
Well, just obviously I need to confer with him and see what is.
So if you'll talk to him about when that will take place, then we'll take care of the warrant.
Okay.
Were you previously on a commercial bond?
Yes, ma'am.
All right, so the other thing, even though I issued a judge's warrant, I didn't issue a bond forfeiture. You may want to talk to the bondsman to make sure that if I recall the judge's warrant without objection from the state and he's going to get treatment, will they then try to come back and do that? So if you'll talk, to ask that they be let off the bond. So if you
Yes.
will talk to them about that, then we'll take care of that. All right, thank you. And Norma, if you can make sure he has a reset.
The judge is in.
All right, who else is next?
I do.
Her attorney is, she's on, but she's not responding. Who's next?
I'm present, Judge Kelly Green for Yvonne Perez.
Just one moment.
Thank you.
All right. Where is Escalante? What page?
Right.
All right, could I have the motion to revoke on Escalante, please? All right, first question. Are you all ready to proceed with the motion to revoke or no?
We would be, but I don't believe they would like to.
We're not the true judge, and setting today was actually first on our motion to set.
Okay, so,
And we conferred about it because he asked us to try to work it out. We just didn't quite get there.
all right. So, Ms. Ferguson, I need a date for a contested hearing, 10 days. All right, your contested hearing is going to be November 10th. Probation, contested hearing on Mr. Escalante, Jose Escalante, November 10th. And state you'll need to be prepared to have your witnesses present.
Yes, ma'am.
All right, the court is calling 2024 CR 1359 State versus Jose Escalante. Can I have parties announced for the record?
Melissa Albin for the state.
Raymond Martinez from Mr. Escalante.
All right, and are you Mr. Escalante?
Yes, ma'am. Yes, Your Honor.
And we're here for a bond issue, is that correct?
Yes.
All right, and state, have you had a chance to confer with the defense on the request for a bond?
Yes, Your Honor, we're recommending $30,000.
All right, and defense, do you have witnesses? I believe you were going to call him.
Just him.
Okay. All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, you can lower your hand, state your name for the record.
Jose Manuel Escalante.
All right, you may proceed, counsel.
Mr. Escalante, first question is, how long have you been in jail?
Up
Roughly.
approximately a week and a half.
And at the time that you were arrested, were you working?
Yes, Your Honor.
And what were you doing for work?
Mambo's Seafood,
And what was your job title then?
dishwasher, maintenance,
Hourly rate?
$13.50 an hour.
Did you report your probation? Have you been reporting probation up until the time you got arrested?
Yes. I've been doing everything I've been supposed to be doing.
We'll get into that the next segment, but they've seen you recently,
Yes,
they've tested you recently.
yes,
Okay. Is there an immediate need for you to get out on bond?
yes.
Can you tell the judge what that is?
I just had my beautiful daughters born, my two twins. They're twins that were just born.
This month,
Yes.
and where are they?
They're in the NICU right now.
And so would you like to be able to spend time with them and make sure they're okay and help their mother, even though you've got this issue pending?
Yes, sir. It'll be a blessing.
Okay, and at the time you got arrested, did you have money saved in the bank? Was it difficult to even come up with a little bit that you did come up with to get you in front of the judge today to request a bond?
Yes, sir.
Okay, and then you're gonna have to scramble and figure out a way to post a bond if she sets one for you?
Yes.
Okay.
And I still have my job there at Mambo's Seafood.
How long had you been there?
Few weeks.
Okay. And is that the first job you had in a while?
No. Yes, sir. No, sir.
So what were you doing before that?
I was doing my own self-business tattooing.
Okay, and so that's still available as well.
Yes, sir.
Okay, and you and the mother are living together?
Yes, sir.
Good terms?
Yes, sir.
The emotional plea for bond. Mr. Escalante's lawyer uses the most powerful mitigating factor available. His twin daughters were just born and are in the neonatal intensive care unit. This is an immediate, life-altering necessity. The defense is trying to leverage this extreme emotional need against the state's recommended $30,000 bond, arguing that a lower amount is necessary for him to be a support system for his family. Will the judge show mercy and lower the bond?
So if the judge set the bond at 12,000, do you think you could possibly come up with that?
Yes, sir.
Any questions?
Just a couple. Mr. Escalante, yes, I know you're not pleading true to anything at this time, and that's fine. But at the time of the new arrest that's just alleged in the MTR, were you working?
Yes.
And at the time of the allegations that are in the MTR, was your significant other pregnant?
Yes.
Yes, she was pregnant, so that was before the babies were born.
Can you repeat that again?
She was pregnant on the day that you were arrested for this new number one that's alleged on October 14th.
No, ma'am, we're going back and forth from the hospital for the NICU.
So the kids were already born
Yes,
when
ma'am.
this happened.
Yes, ma'am.
Okay. Nothing further, Your Honor.
All right, I just have a few questions. So in the past, have you ever used any type of controlled substance?
In the past, oh, but yes. The past.
All right, and in the past, what would that have been?
Xanax.
And what else?
Yes. Cocaine.
I'm sorry, what?
Cocaine. I apologize.
All right, and I think the last time you were here, you were saying you were going to go in the military and
that's-
have your tattoos removed because
Yes,
they
ma'am.
did it for free.
Yes, ma'am. And I was doing all that and everything like that. I had went to the recruiting office on military, and I was talking to my probation officer, and my probation officer told me to wait on that because she was gonna go and conversate with them and further look into it, because when I went and told them how you gave me the permission and everything like that, they tried to tell me, oh well, you got to go to a different branch because the quota that they met was already over with, so I had to start the quota over in November when they start the new quota, and then they'll be able to accept me and further everything else. Because you gave me that chance, and I took off and I ran with it, Your Honor, and I was doing everything I was supposed to be doing.
Your Honor, may I say something?
Yes.
Normally on a motion to set bond, I would offer you the police report of the new offense, but the court summary summarizes it. So I was just gonna ask if the court would like to see that to understand the circumstances of the new allegations.
Any objection?
Non-hearing judge, so you're allowed to.
No, I'm just, any objections?
I do object, but I understand also the rules allow it, so
Yes.
May I approach?
I don't look silly objecting to something.
No. I always tell people to do an objection because my understanding is that this is a summary of what someone read, and it's not necessarily the police report.
Also fair to, when I think that you are, the way it's before the court now is not gonna be as fun.
All right, is there anything else?
No, you're welcome.
All right, this is what the court is going to do. The court is going to set your bond at $40,000. There's to be partial GPS for employment and medical appointments, waive GPS fees. There's to be no residing in household with minors. And there's to be no unsupervised contact with minors. All right, thank you.
Will
Yeah.
that partial allow him to go visit the kid?
Yes,
Thank you. Thank you.
all right. You're welcome.
Yes, be done.